Well, I'll introduce myself a little bit, my associates, my firm, but first, this is going to be for credit. You get CD credits for this. It's going to be 1 hour. At the end, I'll take your cards. We will collect those, and then I will send you your certificate via email, and maybe send you a couple invites to some of the events that my firm holds and whatnot, because we do happy hours frequently, et cetera, et cetera. So just to introduce my firm a little bit, John Beleza from Diamond Law Group. We have an office right here in Massapequa on Merrick Road across from Burns Park. I also have another location in Smithtown because we like to cover both counties. So we're rapidly expanding. We opened that office about a year ago. We have 21 staff members, multiple associates, myself being one of the partners. I have one partner, Rich Klein, who some of you may have met as well. So that's a little bit about the structure of our firm. I have my associate Haley with us today and my intern Johnny, who's our cameraman. Thank you, Johnny, for coming and taking time off from school. So about the firm itself, though, we operate a little differently than most firms on Long Island. Rob can attest to that. He's worked with us, but we also have an agent that's worked with us on the other side, and we give you an interactive website portal. Monica's worked with us in the past as well. You can log in, you can view your transaction 24 hours a day, 7 days a week. We upload documents, you can download the title report and the contracts. Literally everything is transparent to you, whether you're on our side, I know there's no sides in real estate, or the other side. We give you a username and password to both agents and the loan officer and the clients, because we're all working towards the common goal, and that's closing, right? None of us get paid unless it closes, myself included. So we all work together as a team. But in addition to that fact, we give you automatic email updates from the website. So there's 12 different steps. When contracts come in, you get an email. A contract's been received. When it's been reviewed, you get an email for that too. And what I've found in my humble experience is that what that tends to do is it reduces my call volume, but it also reduces your call volume from the clients who are inquiring, what is the status of my transaction? So my website is getting ahead of that before you get that phone call. But in addition, we have a very, very strict, Haley will attest to that, follow-up schedule. And we blind copy or copy you to follow-up as well, accomplishing the same goal. And that's to get ahead of the client calls and the client inquiries so that we can all do more business together and thereby make more money together. Right. Anyway, enough about myself and the firm. I don't like to talk about that too often. So let's talk about substantive stuff. Today's class will be surveys and COs. And while that is a legal aspect and not something that you necessarily want to give your client legal advice about, you can then use these tools and tips that I'm giving you to add value to your client services. We're all referral based, right? We get our clients based upon past clients and referrals from friends and family. So adding value is something that we love to do. So along those lines, surveys, right? How many of you have been in the situation where we get the clear to close and the attorney's like, sorry, waiting on a survey, right? Yeah, right? That happens all the time, and they're like, dun, 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 and it's kind of deflating, and you're like, ah, crap, now we gotta wait to close. So how do we get ahead of that? Well, as a seller's attorney, we're gonna switch hats, right? Throughout the transaction, I'll give you a seller's attorney's perspective, buyer's attorney. As a seller's attorney, I always like a buyer to use my survey, the seller's survey. Why? For a number of reasons. A, it speeds up the transaction. Most survey has 10 to 12 business day turnaround time. That's 2 to 3 weeks, right? That's a long time, right? So you get clear to close. Maybe the timeline is tight on the on or about date. And now you're waiting 10 to 12 business days for a survey because the buyer's attorney slept and didn't order it quickly enough or whatever have you. Most buyer's attorneys will order their survey at the time of commitment. You have financing line, great. Now the buyer's bound to the transaction, let's go with the survey. And at that point, we'll order. But sometimes, depending on the timeframes in the contract, that commitment date, or when the commitment's issued, could be very, very close to the closing date, right? And that's when you're experiencing what I mentioned before, the delay in closing due to a survey. So as a seller's attorney, we like the buyer to use our survey, right? We don't have to wait that 10 to 12 days. They just read into the title report. It can be done right before the commitment's even issued, and we're just moving it along. The other fold to that is that they don't guarantee the fence lines. By they, I mean the title company. They look at the seller's survey and they're like, well, it's an older survey. The fences could have changed. We don't know where the fences are currently. So how many of you have heard of out of possessions, right? And that comes up and that further delays your transaction. So now you're not only waiting for a 10 to 12 business day turnaround on the survey, but maybe an out of possession comes up on your new survey. Well, if you use the seller's survey, that doesn't come up. And then you don't have to wait for a survey and you don't have any issues that come up with the fence lines. So
why doesn't it come up? I don't understand.
Because it's an older survey. So let's say the survey was done in 2007. Well, it's 2021, 14 years later. Who's to say those fences haven't changed, right?
Right,
If
that's
so,
why
they
the
can't-
other
so-
side wants to
So the
address
title
it.
company says, we don't insure the fence lines, they're there for informational purposes only, et cetera, et cetera. And I'll get into out of possessions, we'll talk about that. So along those lines, now I'm gonna put my buyer's cap on for a little bit, okay? As a buyer's counsel, it says literally in my retainer, we always recommend a new survey, irrespective of whether the seller has one or not. So the buyers put on notice when you retain me, hey, we can use the seller survey, but otherwise we're going to order a new survey. It also says we order it when it's at the time of commitment. So we give them the option. If you want to use the seller survey, we talk you through it, the pros and cons. We always recommend an updated survey because it shows the home as it presently exists. It's the most protective. You can use that for building in the future. It guarantees the fence lines. Now, what do we do with these surveys, right? What does the seller and the buyer's attorney do with these? Like, why do we need a survey? Forget about the fence lines. I also use it to check dimensions of COs, right? So I get these COs come back, and I've never been to the property. You guys have been multiple times, but the attorney typically doesn't go. So how do I even know what's going on there in terms of the COs? Well, the interior is always a question, right? I can't tell if added bathrooms unless somebody alerts me to that fact, or even garage conversions unless somebody alerts me to that fact, or I can kind of piece it together with the listing. But what we do is we take the survey, we look at the COs, and then we look at the listing, and we compare them all to see if anything's out of whack, if there's a missing permit or something of that nature. So it's twofold. We're checking the fence lines. We're also looking for permits on improvements to the property. And then there's a third layer of complexity. After we do that comparison, then we have to look at the contract or our notes to see what was negotiated in that contract. Because how many times have you seen the negotiation in the contract where a CO comes up and it kills your deal because there's no CO for a deck or there's no CO for something, right? That brings me to my next topic of conversation. So now we've established as a seller, we like to use the seller survey. As a buyer, we like to get a new survey. Next topic of conversation is how to proactively get ahead in these situations. As a listing agent, you can ask your seller for a survey, right? And then you have that document going forward. At the moment of you listing the property, you can ask for that. You can ask for copies of your COs. The survey will speed up the transaction during the transaction, but the COs and the survey combined may speed up the transaction pre-contract when the attorneys are negotiating. How many of you have been involved when we're going back and forth, meeting the attorneys about COs, and randomly some attorney reaches out to you and says, hey, did you pull the FOIL request? Can you send me copies of the COs? Or maybe they ask the client to do so. I've done it myself. And the reason why we're asking for that is because there's something being negotiated in the contract in terms of CO exclusions. People ask me all the time, usually first-time home buyers, they say, well, do I have to have COs for everything? The answer is yes. Yes, you do, right? And why is that? Because when you file a permit for something, the town typically raises your taxes. When I say something, what does that include? Most people are like, oh, well, additions, dormers, things of that nature, extensions, big things. Wrong. You need it for retaining walls, you need it for sheds. Some municipalities require for a patio. They do it for everything. Central AC. Again, you need to use a real estate attorney to know the complexities because some towns require it for some things and others do not. By way of example, Dix Hills, Huntington Township, they don't require COs for AC permits. Town of Oyster Bay, they do. Okay, so now the reality of it is many homeowners don't file for smaller things, and that's why you've heard that misconception is, oh, you don't need it for that. Well, that's because people just don't file for it. Why? Because they're avoiding taxes. Anytime you file for something, it raises your taxes. So things that are quote unquote removable by their nature, many homeowners tend to not file for those because if a shed doesn't have a CO and the town raises it, the homeowner says, I'll just take it down. Many of them just put it back up after the town leaves, but that's neither here nor there. So that's why people don't file for it. So a lot of buyers have this misconception that, hey, you have to have these things. And circling back to the townships, in certain townships in the Hamptons, the town does a site inspection on every transaction. So when your title order goes in, they send somebody from the town to go inspect. And they check those COs because they want their tax money. That township is smart. Every town should do that. It would make all of our lives a lot easier. But the reality of it is they don't, which makes our lives difficult. So again, circling back to being proactive, if you pull the surveys and the COs, you can proactively get ahead of these issues before they arise. And then when that pesky attorney reaches out to you and says, hey, did you send that FOIL request? It's like, yes, I did. Here you go. Or you send it with the binder, and then we can tailor the contracts accordingly. We know what's going on before it happens. That's the key in the business, is to be proactive. So I always tell listing agents or agents in general to ask these questions, ask about the COs, ask about the permits, because you don't want to get in a situation where you have an accepted offer, you do a home inspection, you start negotiating the contract, and the deal just falls apart because of a CO for a deck that all could have been disclosed and avoided ahead of time. I was talking with Rob and Joe Salemi, two of your counterparts here, before we started and before everyone arrived. And, they said to me, they're like, yeah, I put you in touch with that client. We're going to take, Joe couldn't be here because he's going to take the listing photos right now. He put me in touch with the client already. This way, if they have questions about the transaction or these things come up while you guys are negotiating the offer, they can call me and be like, hey, John, what should I do here? Hey, Rob said this. What do you think? And I'm there as a resource rather than when the offer gets accepted, the inspection's complete, they're like, send out the contract. And I'm like, I haven't even been contacted by this person. So again, you proactively get ahead, get in touch with the attorney, pull the COs, pull the survey. These things can't hurt. And yes, you cannot give legal advice, but your clients will be like, wow, they're asking the right questions. Right? You're asking about service, you're asking about sales because you are knowledgeable and you're adding value to your client by doing so. I'm going to stop right there. Does anybody have questions on any of that thus far? No? Okay. All right. So on surveys, to circle back though, let's talk about out of possessions and then we'll go back to COs again. So out of possessions, the bane of my existence. I literally hate them. I'm going to give you a little background before I explain what an out of possession is. I wrote a paper on it in law school. I was just telling my associate and my intern that property was my least favorite class in law school. Literally, I wanted to be a criminal law attorney. Now I'm a partner of one of the biggest law firms, real estate law firms on Long Island. Funny how that works. But in law school, I wrote a paper on what's called adverse possession. And that is where, and they're behind the scenes shaking their head. I don't know if that camera can see that, but they're all smiling and shaking their heads because it's something you learn about in property law. And it is very, very difficult to prove. It is a 10-element cause of action that you have to prove developed by case law. Case law is law that is not on the books. It is developed by cases, by judges' decisions. That tells you it's very complicated and annoying, right? If it's law, it's written right in black letter. If it's case law, it's developed by cases. So anyway, there's 10 elements, very, very difficult to prove. I'm not going to dive into a law lecture. It's very boring and falsely. Just know that it's very, very difficult to prove these 10 elements when I go through what this means for you. So out of possessions, again, it's not law. It was developed by case law. So what does that mean? Well, the title companies have to insure, that's IN, not insure, the transaction. They literally insure it that there's going to be no claim on that property. If a fence is encroaching over 1 foot, in excess of 1 foot, the title company will not insure that fence line because of a claim of adverse possession. The neighbor could technically come and sue the homeowner, the seller, to obtain that strip of land. Okay? Very, very rare, very, very hard to prove. The reality of it is nobody's ever suing over 1.2 feet. This is an archaic common law. Again, common law is case law that was developed back when Long Island and New York was all farmers and everybody was farming each other's land. You could actually steal another farmer's property by maintaining it for 10 years. And they used to do that and people would steal each other. Oh, this is my land now, I've been maintaining it for 10 years and they would just take it. And it has to be under a good faith claim of right. Anyway, it's very, very hard. So when does this come up? Why is this a concern of the title companies? Well, it could come up, and the title companies are in the business of insurance. So they have to protect against occurrences that could happen. But in reality it comes up when they go to sell, right? And me as the attorney, right, if it's never gonna happen, why do I care? Because I don't want this to come up when they're gonna go to sell. Then my client, maybe I represent them, maybe I don't. My client comes back to me and says, how did you not protect me regarding this? Now I have to deal with this? That's why it was developed. But the language of out of possession case law, Governor Patterson tried to write a law around it back in the day. And he said, any encroachment which is de minimis, shall not arise to out of possession in the state of New York. That sounds great, right? Wrong. What does de minimis mean? I don't know. Sounds like something small, but what's the actual measurement? Nobody knew. So the title underwriters, right, because title companies have underwriters that insure, they developed the in excess of 1 foot verbiage because they felt that was appropriate. So now we're in the situation where we're in. How do we get around this, right? How do we get around this? Well, first of all, pulling the survey sometimes helps. I can tell, even if it's an older survey, I can ask the homeowner, hey, are the fences still there like this? Did you ever move them? Because I can tell from the survey if they're off, so we can get ahead of it in that fashion. But there's ways. It's not the end all and be all if an out of possession comes up. There's 2 ways to get around it, or 2 documents to get around it. One is known as a fence affidavit. The other is known as a boundary line agreement. You may have heard both of those terms used. They are not interchangeable. They mean 2 very, very different things. A fence affidavit, and we've Oftentimes, the attorneys have called upon the agents to facilitate the signing of these fence affidavits by visiting the neighbors. Has anybody been called? Rob is saying yes, and Monica's saying yes. We've called upon you to facilitate them, where you knock on the neighbor's door and you're like, "Hi, I'm the listing agent for the person next door. Here's a copy of the survey. You're encroaching on my neighbor's property." It's a difficult conversation to have, but some people are receptive to it, others are not. The fence affidavit is a little bit easier to massage. It is a document that does not, quote unquote, here's a legal term for my law students and attorneys, run with the land, right? It is a document that is specific to the individual. The affidavit, the person is signing, and it does not bind any subsequent owners. So, most attorneys will take an affidavit, myself included, because boundary line agreements, which is the other document, requires a social security number to be recorded with the county and run with the land. So the difference between the two documents, both are notarized. One is recorded, one is not. The affidavit is not recorded, it only binds that neighbor. If that neighbor ever goes to sell, it is not binding on another subsequent owner. So that out of possession remains, and it will rear its ugly head, irrespective of the piece of paper that you have signed when our buyer goes to sell the property. So the boundary line agreement is the other document, and it sounds more appropriate, right? And it is the more appropriate way to solve these fence issues. Again, the reason why we don't use them predominantly is because of social security numbers, because neighbors are less likely to provide socials because it makes people uneasy. But there's another layer to that, especially here in Nassau County. Documents in Nassau County are ridiculously expensive to record. Boundary line agreements are multiple pages. When we have to record these documents, it costs $1,500 to record them. Do you know what my legal fee is? $1,500. People are like, "I'm not paying that." The seller will say that because they're like, "I'm not even paying you that." I agree, my legal fee should be higher, but that's neither here nor there. So that's why we use these fence affidavits, because it's ridiculously expensive for the parties to record it, and it's also a burden to most neighbors to sign it if you ask for their social security numbers. So a lot of times, irrespective of what document you ask them to sign, what does the neighbor say? "I want to speak to my attorney," right? Immediately. And rightfully so. You're asking them to sign a legal document, right? And I always cringe because sometimes it's Uncle Joe, other times it's an attorney that I know. And when it's an attorney that I know, a real estate attorney, local person, they're usually like, they talk through it, and I do the same thing for my colleagues, and I talk to the client through the issue and I explain it. Why do I talk to the clients about that? Well, when I'm buying, do I care if the fences are encroaching on neighbors? No, I don't. So that never even comes up. So there are times where my clients call me up in the future and they're like, "Hey, my neighbor's selling their house. They're asking me to sign this document. Why did this come up when I bought?" I'm like, "Well, you're gaining 3 feet of land. We didn't give a crap." And they're like, "Well, they want me to sign this that says that the fence can be moved." I'm like, "So tell them to strike that portion and that the fence can remain there." And then they can sign that document. So, conceptually speaking, we work through these issues together as a real estate community. So it's important that you have knowledge of this, because it does rear its ugly head, and it always delays closing. Let's be honest, like the survey always delays it, and then if there's an issue with it, that just delays it further. So proactiveness is the name of the game. Does anybody have a question on either of those documents? Because then I'm gonna get around using either of them. Does anybody have a question? No? Okay. So attorneys are lazy, right? I'm gonna start off with that. Most attorneys don't wanna do any of that. You ask them to draft documents like, "Oh, I'm gonna charge my client $250 to draft this." And they get all like nasty about it. So there's other ways that we can negotiate around this. And a lot of attorneys, especially non-real estate attorneys, don't even know this, all right? The first question that you should ask, is there an abutting fence? If there's an abutting fence, what do I mean by that? Fence here, and there's space in between it. That's what I call it, no man's land, all right? If the fence is encroaching on the subject property by 1.5 feet, but then there's another fence that's like on the property line, well, how can that neighbor lay claim to that property if they have their own fence that's on the property line? They can't make a good faith claim of right, which is one of the 10 elements that you have to prove, to be able to lay claim to that property. So then a savvy real estate attorney will get a picture of the fence line showing an abutting fence, submit it to the title company and say, "Hey, title company, your surveyor was silly and didn't note the abutting fence in the survey. How can they make a good faith claim of right?" And I've battled with title companies because title companies don't want to change their position because of whatever reason. And I've battled with people and they can't raise this, and I've made it go away in that fashion, if we're that lucky. A less lucky scenario are what I call natural boundaries, okay? What do I mean by that? Trees. Very good. Tree. But not just any tree, not like a little tree that I just planted when I moved in. Big trees, 100-year-old trees, right? If a tree has been there for 100 years this wide, you can't put the fence through the tree, right? So conceptually speaking, that makes sense. And you have to explain that to the title companies. Hey guys, you can't put a fence through the tree. The title company's never been to the property. They are basing it off of the survey, and the surveyor doesn't mark the trees on there. So, and I've run into situations where the title company says, well, then it should have really just jutted out at that one section. And I'm like, look, they don't jut out fences in one section. They put it in a straight shot, and they did it diagonally, and that's why it's kilted off. So you have to explain these things. But the only way to do it is with a clear picture. And again, I've never been to the property. So if you work with my office, when I raise these issues as a seller's counsel, I'll be like, hey guys, we requested the deed and the affidavit, but send me some pictures of the fence line. Maybe I can make this go away without even annoying your neighbor. So the tree can sometimes work, right? There's another one that many of you have heard, and this is the oldest one in the book, but it's not the best one, is a gate, right? How many of you are like, oh, install a gate, right? Or take out a section of the fence. That's all well and good. I'll tell you why that's silly and why it doesn't work always. The claim of adverse possession is 10 years, right? So they're saying that if the fence hasn't been there for 10 years, you can remove a section of it. Now you have access to that area, destroying the 10 years. So some title companies, American Homes Title, which we'll talk about your affiliates in a second, American Homes Title is smart, and they will look at it conceptually speaking and say, okay, fine, you want to install a gate, you want to remove a piece of fence? Show me how long the fence has been there. Show me the last time it was installed, because then now you've established that it's been there for less than 10 years, or whatever have you. If the fence has been there for more than 10 years, moving a section of the fence, installing a gate does not work. So the smart title companies look at things conceptually speaking, will ask for these things. Some are indifferent and will just say, okay, whatever. And then others will be sticklers. So you need a real estate attorney that's aware of these things to kind of coach the title companies who should be aware of it. But let's talk about using your affiliates. Please use them. They're here for a resource, right? Your buyers should use them. I have a very, very good working relationship with Lori. I have a very, very good working relationship with American Homes Title before it was even associated with your company. I know them very, very well. And when I need something, because it's imperative that I get it at a certain time to close the transaction in a timely fashion, I can call upon them to do so. And they do it immediately. I have other agents that I work with. I'm not going to name names of agencies or title companies or whatever that have non-affiliate title companies that they work with for whatever reason. And I don't have a relationship with them. So when I ask them for things, whether you're copied or not, they just kind of backseat me. And I have to then call upon agents to push it through with that title company because they required me to use them. You should be using your affiliates. They're there for a resource, for a reason. Just the other day, and please don't abuse this, I did it for a client. They did a pre-title search on a lien search, not the CO search, because those cost money and they take weeks to return. But Lori ran a lien search for me because it was a good client of mine, and I asked him to do me a favor with an agent that we work with frequently. These are your affiliates. That's what you have them for. Your lenders in your office too. That's what you have them for. I always like to finish up these things with the affiliate, touching base on affiliates, because how many times have you guys driven around with your buyers and you show them all these houses and they get priced out because they didn't speak with your loan officer. They used their own loan officer, and then it turns out they can't even afford the homes that you're showing. And then they hate every subsequent home that you show them because they fell in love with one that they can't even afford, right? So please pre-approve your buyer with your lender. Use Lori as a resource. You have questions, you can use me as a resource. Call me up. I give candid advice on deals that I'm not involved with at all. There's a Coldwell Banker agent in your Smithtown office, a counterpart that's located across the street from my office. Just yesterday, the client was unhappy with their attorney. So the wife is in touch with the agent more. The agent's like, here, John will speak to you. If you want to retain him, great. If not, don't worry about it. We spoke with them, coached them through it. Ultimately, the husband wanted to stay with their attorney who was like related to them or something. Fine. But they couldn't get the deal in contract. So they called me up, I gave them candid advice, and they went on their merry way. I don't mind doing that. Use your affiliates. They're your tools at your disposal. Use them. Questions? Anybody? No?
Survey inspection.
Yep.
So if you have an old survey, you have an inspector come in, how does that come into play with like boundary lines?
That's a solid question. So I usually use the last half hour for question time. And then I'll touch upon COs with surveys again. But yeah, survey inspection, which brings me to surveys and COs. That's a good segue. Survey inspection. Survey inspections are only for existing surveys. So I told you before that my office and every attorney compares survey versus CO versus listing versus contract, right? A survey inspection is when you use the seller's existing survey, and we still do that same process. But the title company, because it's an existing survey, has to send somebody to the property to show you what changed, and then they give you what's called a survey inspection, right? And they tell you, okay, this is what's on the survey. There's the regular house, there's a deck, there's a dormer. And sometimes they don't even tell you dormer because they can't tell. So they just leave it off, which is concerning. Neither here nor there. Deck, home, etc. And then it says, changes since the survey's been done. And then it'll say extension added, central AC added. Because on the original survey, that wasn't included. And then that clues me into the fact that, hey, that was added. It's not on the CO. So to Rob's point, but a lot of attorneys like using existing surveys because it does their job for them. Sometimes, and then if something goes sideways, they blame the title company, even though it's not for insurance purposes, which I'll tell you. But what do I mean by that? Well, the title company is basically telling you these things were added, so just check your COs against them, right? So they're telling you what you should be doing, right? On a new survey, it's going to be a brand new survey, so they don't tell you what's changed, so there's nothing to compare it against. You actually have to do that work as the attorney. So the survey inspection is using a prior inspection. The title company will actually tell you what to raise and what not to, essentially. What did I mean by they don't insure it? Title companies do not insure COs. They are run for informational purposes only. You don't get title insurance for it. The attorney uses that as a tool to review the search versus the survey and whatnot, but you do not get title insurance for it. Some attorneys don't even run the CO searches. So you gotta be very, very careful with that. Okay? But yeah, so on a new survey, they do what's called a reading. They don't have to send somebody. The survey is brand new. It shows everything as it currently depicts, the survey as it currently exists, and the surveyor actually guarantees that survey to the title company that it's accurate. They put their stamp of approval as licensed professionals just like you and I. And they put their stamp of approval on it, they guarantee it to the title company. They can be sued if there's a claim from the title company, from an owner of that property. They can actually drag the surveyor in because they put their name on that. Okay? They're licensed just like you and I have liability, they do too. So let's talk about the CO aspect of it.
Well, can you,
yeah.
can I add something? Can you, and I think I've described this before, but it may be helpful for you to do this, to describe to them the difference between a guaranteed survey and a survey that's not guaranteed.
Love it. Yes, we'll do. We just had this come up yesterday, Haley and I. So yes, a guaranteed survey versus unguaranteed. So surveys can be done for many different purposes, right? You have a building department survey, you have a title survey, etc. Title surveys have to be guaranteed for a title company to use it. What does that mean? It says right at the bottom, either guaranteed or certified to. They'll say party name, lender, if there is a lender, and the title company. It doesn't matter who it is. It could be the current owner, it could be 2 owners ago, but it has to have those guarantees. That means that the surveyor is guaranteeing it for the title company. If it's an unguaranteed survey and there's something wrong with it, the title company can't pull that surveyor into any eventual litigation, if any. So the title companies will not use a guaranteed survey, an unguaranteed survey, sorry. So that's why I'm asking you, if you pull these documents up front from your seller, I can usually look at it and see if it's a guaranteed or unguaranteed survey. That's not the end all be all with it either. You can use an unguaranteed survey. You got to call the surveyor and have them add guarantees. Then when you call the surveyors know the business. So they'll be like, oh yeah, $400. New survey's $550. What do you mean? So then at that point, it's like, do I want to use this existing survey that they're going to put guarantees on? I'm going to have the client spend $150 and get a brand new survey. Probably the latter. So it all depends. Some surveyors are reasonable. They do it for like $200, $250. Some do it for free. So it all depends on who you get. But yeah, the unguaranteed survey versus the guaranteed survey is very, very important. A lot of times I'll get a survey from clients and it has like the cesspool drawings on there or whatever. That's from when they built the property. That's a building department survey. They submit that with the plans. That is not guaranteed to anybody. It's just submitted to the building department. The building department then uses the survey when they come to check the COs, similar to what the attorneys do when we check the COs. Not doing things. So yeah, a lot of people, circling back to the COs, have the misconception that there are that COs, you have to have them for everything and they're insured by the title companies, and that is exactly what I said. It's a misconception. You can buy a home in any fashion that you want. You can buy a home without COs for anything. In fact, I'll give you story time. I love giving this example. Lori's heard it since I started in the business. I think Rob's heard it a bunch of times too. It's about my childhood home in Wantagh that we recently sold, actually. My parents moved out to Southhold, good for them. But my dad's an old school Italian guy. Hates paying taxes, right? So over his 30 years of home ownership, or I'm sorry, 37 years of home ownership that he owned that house, he didn't file permits for anything. It's a 1912, or was a 19, or still is a 1912 Dutch colonial. Beautiful, tons of character, nice banister, woodwork, beautiful, beautiful house. But it's old. So over the years, my dad put, ready for this? Front porch, shed, bi-level deck, above ground pool, knocked down the existing garage, built a car and a half. Here's the kicker. Has a attic, third floor attic, that he made into living space for his master suite. Put a bathroom up there. Because it had pull down stairs, he dormered the back of the property, put a staircase in, all without a permit. Isn't that great?
Right.
Yeah.
Love him.
My dad's like, can you represent him? Like, no. Of course I represent him.
Never go to
But-
myself.
Yeah, right, exactly. But I just said we sold, right? Didn't we sell? And we sold with a lender. How did we do that? Proactiveness. Now, my dad took a haircut on the property for sure. If he legalized that stuff and did the right thing, he probably could have got more money for it. But he took a little bit of a haircut. But he had to get ahead of it with his buyers. You have to disclose these things in advance. There was no CO for anything. It predates COs. It was 1912, no letter in lieu. I had to coach the agent through it a little bit and disclose these things. And she was a little resistant. She's like, oh, nobody's going to buy the house. I'm like, you have to massage it a little bit. And she was great at it. She did a great job. We took a little bit of haircut. We had to use a lender that was okay without COs, right? Some lenders will raise it. And you can get ahead of these things. Don't use BetPage on a deal with CO problems. Just don't.
No.
I mean, it shouldn't be anyway, but neither here nor there. People like BetPage because it's a credit union, low interest rates, but they can't get things done that other lenders can. So circling back, I like to circle a lot. CO, you can buy a house with anything you want. It could have no COs. It could have all the COs. You can buy a house in any fashion you want. The attorney has to contract around it. You have to be protected and you have to have knowledge about it. And again, adding value, if you speak intelligently to people about surveys and COs and just get ahead of it, put them in touch with me. I can coach them through it this way. When these issues all arise, it's not a shock. I found in my practice that if you just communicate and disclose everything up front, it just makes your life so much easier. And most attorneys suck at communicating, so it makes me shine like stuff. Let's be honest. Questions? Anybody? No? Okay. Well, like I said, I'm always a resource for you. If you have questions after this, you contact me at any time, email. I usually respond within minutes, phone call. Great. Yes?
Is there any CO that, like, I always hear that you don't need the COs and banks, commercial banks are okay with it. Is there any exceptions to that? Like, you absolutely have to have a CO no matter what lender it is or no matter?
Most lenders want a CO for the house itself.
Right.
Like what I was just saying, there's no letter in lieu, there's no permit for the house. Most lenders want that. But I shouldn't say most. There are many that don't. Like that guaranteed rate doesn't require anything. Don't close on anything. Let's talk about that for a second. That's a good point, and I used to speak about this at length. Why do banks even care? Right? Why do they care about permits?
So,
In the event that they have to foreclose on the property and then resell the property, they look at it as a house without permits or missing permits is less marketable, and they won't be able to recoup their money. There's a second layer of complexity to that, which is totally unfounded, which is liability. They think that, let's say, a finished basement is not legalized, and God forbid, somebody's sleeping down there and dies, right? Then the person that sues the existing homeowner can come after the bank as well. That is totally unfounded. Obviously, they can't. But again, they can take the house from them, and there's a mortgage on that house, right? So there's layers of complexity to that, which become nasty. So the banks try to get around that and get ahead of it, I guess, so to speak. But yeah, you don't really need it. Let's talk about the basement for a little bit. Finished basements are probably the most common, right? Nobody, or I shouldn't say nobody, but most people don't have permits for that. Why is that? Basements in any type of quote unquote living space is taxed by the square footage. So if the basement spans the entire footprint of the house, well, your taxes go up exponentially, right? That's why people don't file for it. Plus, it's on the interior of the home, so it's in the basement, it's downstairs below grade. So it's very unlikely that the town is ever going to catch wind of it, right? They can't just drive by and see a basement. They can't even walk in the backyard and see a finished basement. The only way they're going to see it is if they come in the house and then ask you to go in the basement, which they may or may not do and usually don't because the inspectors are lazy. So a lot of people don't file for the finished basements. Now, if you have an open permit, you go to file for something else. The town could ask to see that, and it'll open up a can of worms. And all of a sudden you're in for a real big headache because basements are hard to legalize due to the egress, right? Anything that's walled off needs 2 ways of egress. You need an escape window, right? In the event of a fire, like I was just telling you. So if there's an outside entrance, easier to legalize. If there's not, and there's no egress window, they have to dig down with a foundation, cut a hole in the foundation, install an egress window. It's very, very costly. So a lot of people don't file for that finished basements yet. You got a question? Okay.
The towns are checking too, MLS.
So I like to say that with COs as well. Please, please do not list illegal structures on your listings. Please don't do that. They surf the listings. I mean, I had one with 3 kitchens one time in Lindenhurst, and the agent put all 3 on it. And very clear, all the countertops are different. It's like, what are you doing? 3 kitchens. Literally the day he was coming in to sign the contract, he brought a yellow slip in that was stapled to his door, or taped to his door. It was his violation.
Right.
Because they surf the listings. Why? The government just gave all these handouts, right? They gotta recoup their money. They want their money. So they are surfing the listings. They are driving around. Do not put illegal things on there. I'm not supposed to tell you how to evade the law, but that's how to evade the law. Your homeowner will appreciate it in the long run.
I made that mistake early on.
Yeah, it
in my
happens.
career. I had a listing in Babylon. They had an apartment over the garage that they built, and she told me it was legal.
It was like,
I think I don't think we never sold it. We actually wound up not selling it because turns out the house was an old houseboat, and the hull, literally there was a hull that was full of, it was a nightmare, but
taking out water.
But I listed it in Babylon as a two family, because she told me it was a 2-family, and we put the accessory apartment on there, and literally 3 days later I got a call from Babylon Village, and they wrote a violation for it.
So that's a great point, actually. Rental permits versus 2-family. Big difference. Very big difference. Especially where we're located in the town of Oyster Bay, by the way, and specifically Massapequa. Mother-daughters, right? That is not a 2-family. Not a 2-family. 2-family homes have a separate electric meter, okay? Accessory apartments have an accessory apartment permit. Mother-daughters have a mother-daughter permit. Many people rent without any of those things, okay? You have to be very, very careful. When you get attorneys involved and you start making these representations about 2 families and mother-daughter versus rental, they will use that to kill your deal in the event that's not, or to squeeze the other party for a credit, or any variation of screwed up transaction that you can think of. So, best practice, even if a client tells you that it's legal, check.
Make sure.
Clients do not know. I bought it like this. What do you mean? How many times have you heard that?
No, we have to check in this office, we have to have rental permits.
I love it. I
I
love it.
get all the time people saying that they have a 2-family house and it's a mother-daughter, or
Yeah, right.
It's not even a
They don't know.
mother-daughter.
Where are the professionals? Where are the real estate professionals? Just gotta act like it, right? So check these things. Don't take people for their word for it. They don't know. They don't know. I can't tell you how many times people say, I bought the house like that, everything's legal. That does not mean it's legal, and it usually is a recipe for disaster. Because unlike you guys who are professionals and myself who are professionals, most of the people in the industry don't even disclose this to their clients, and they just buy houses however they want. I bought it like that. My attorney didn't tell
Well, they
you.
give
No.
you an old permit. Like,
Or-
you have to check, make sure it's been redone.
I have a deal right now. It's supposed to be closing in a week. The seal search comes back. There's an open permit from predates my client's ownership. She's like, why is this coming up? I'm like, I don't know. I'm sorry. Yeah, I don't know. Somebody missed it when you bought. Like I try not to throw people under the bus, but I don't know.
I had both those things happen when I sold
It
my
happens.
house. The fence affidavit was 1.6 feet. Had to have my neighbor sign it. And
Your specific home.
right, and then I bought my home from Charlie, who flipped it,
Water up.
and it went 2 times without noticing that they never got a
This one was interesting.
permit for the sewer.
Yeah. So the guy before Charlie never had the hookup for the sewer permitted. And then he
It was
bought
never
it
closed out, really.
and sold it, and it never came up. And then when Dana went to sell it, it came up.
A lot of attorneys do that. They don't pay attention to the sewers because sewers have been around for so long in
Yeah.
Nassau County. They've changed over. Nobody even looks for it
Oh.
because they just assume that it's okay. So I mean, he's a Suffolk guy now.
Listen, I have
Me too.
sewers.
So you have sewers?
I have sewers.
I have cesspools, so that was a huge change for me. Like
No.
cesspools are like crazy.
Another quick multifamily story. I had a lady in Brooklyn. I'm still dealing with her. She calls me. She has a 3-family home that she wants to sell. I'm like, great. It's investment property. It's stocked with renters. Everything's good to go.
Good
Properties-
rent, everybody's paying.
Property is valued over $1.5 million. Like just the rent roll's good, good solid investment property.
Paying on time.
Could have listed it, but I said, let me do a little bit of background research. I called an expediter that a friend of mine had him look into the property. It was a single family property
Captain
that had actually a friend of mine, Rex Carnoff, he doesn't do New York City driving,
Oh, okay.
so a buddy of mine, Rex, but it had a rental permit for 3-family back in like the 60s that they never renewed.
Yeah, you have to update.
So she was operating a 3-family home out of a single family property. Violations were piling up. She lives in South Carolina. She had 35 violations on the house for operating as a multifamily property.
And in the city, they're monetary, so they charge
Crazy.
They charge you money.
This woman's whole world shattered, and then
And she didn't even know.
she didn't even know. She thought she had like $1.5 million property. It's probably
Free and
worth
clear.
like $600,000 as a single family. There's ways to legalize it into a 2-family. Legalizing into a 3-family is a whole nother ball of wax, especially in New York City now. Now there has to be a centralized meter for your superintendent. There's a million different things, so she can't even bring it to 3-family without spending hundreds of thousands of dollars. to get
Two
rid of it.
comments on that. Number one is on my parents' situation with the 3rd-story attic. Do you know how you have to legalize the 3rd floor? Very, very complex. Most of these, when you don't file permits, it's because it's complex. 3rd story in Nassau County, you have to have a fire escape on the outside of your house and a commercial grade fire sprinkler system in the 3rd floor. Both of which my dad was never doing. The second portion of this though is the what he mentioned with the accessory apartment. You have to renew it. So a lot of times I'm okay if it says expired rental permit and I'm a buyer and it expired like 3 years ago. Sometimes I'm okay with that. Why? Because the buyer has to refile anyway. Now that can still jam you up though, because if they changed anything from the time that permit was issued, then the town could raise it when they do their inspection for the new buyer's permit. So every time there's a change of ownership, you have to refile your rental permits. So not because it's an expired permit, that's not always necessarily a bad thing. It's when there's no permit at all for a rental. And again, even that's not a bad thing as long as your clients are aware of it, right? I always say, my partner and I always say, I am a counselor at law. They call us counselors. If I was a decision maker and told my clients what to do, they would call me a decision maker. I'm not, I'm a counselor. I can only tell them what could happen. I don't make the decision. So where agents will say, oh yeah, attorneys kill deals, I counsel my clients. If there's no permit, I can tell them what could happen. I do not tell them, do not buy this house. That's not what I do. I'm a counselor. I'm not a decision maker. Any more questions? No. Again, use me as a resource. I need to take your cards because I have to register you with the state website. I will pull your license numbers so that you are properly registered, and I will also give you a paper copy of your certificate for your records.
Awesome. Thanks, John.
And John also brought a delicious breakfast with him, so thank you so much.
Thanks, John. Appreciate it.
Yes, we have breakfast for days out there.